Hey guys, I'm Maureen Mahood, broker owner of Sell Your Home Charlotte here in beautiful Charlotte, North Carolina, and I am here with Josh Lipack from Grabowski Law, and we are going to talk about some things about sellers' obligations in the contract when you are selling your house to the buyers when they're buying your house. So we're going to talk about seller obligations in how they fill out their residential property disclosures, what happens in due diligence when you find repairs that need to be made that maybe the seller said there was no issue with, and then the due diligence request when we agree upon repairs, and then if the sellers decide that they are not going to fulfill that actual obligation after they've signed for it. So I'm going to hold this over to Josh, and we recently had a transaction where he was the attorney and I was the buyer rep, and this exact thing happened to us. So we thought it was a good thing to make a video about. Hey Josh.
Hey, thanks for having me back. So as far as sellers' duties to disclose, you want to make sure, as a seller at least, that you're not saying anything that you're not 100% sure about. For example, if your AC unit works, and you know that it pumps out cold air, you could say in your disclosure, that it's fully operational, but maybe you don't 100% know. There could be something wrong with it with closer inspection. So oftentimes they do no representation, which isn't going to be very helpful for you, but that's why the due diligence period exists, for the buyer to make reasonable investigations. What a seller doesn't want to do, though, is disclose or fail to disclose material facts that they have actual knowledge of.
Okay, so let's use the air conditioning HVAC as an example. My AC works. It's worked all summer. It's great. I've got cold air. I'm selling my house. I go under contract, buyer. I put works as intended, no problems, because it's yes, no, or no representation. I disclose the year of it, and then the buyer does an inspection on that AC unit and finds out it needs Freon, or I don't know what it could find out. So at that point, I didn't know it, so I'm okay.
Yeah, you didn't breach your duty as a seller because you didn't have reason to know that it wasn't working to its full capacity.
Okay.
Let's say, because as intended is kind of a term of art, so that can be kind of a gray area. But yeah, no, as a seller, you wouldn't have breached in that situation. But once the buyer discovers it, they would have reason to go to the seller and make that request that it be brought to full operation as part of their due diligence request.
Okay. And then
because the seller said that it was fully operational.
Because they said it. So what if so in the case where they would be in trouble would be if they knew that the HVAC didn't work, but they said it worked. And then you go, and I guess it would be hard to prove that they knew.
That would be difficult. You would need a smoking gun. You would need, an email exchange between them and a contractor where they were informed, something that was pretty black and white.
Gotcha. Okay.
Because they could argue, I didn't know it didn't work. I never used my AC. They're probably lying, but can you prove it?
Okay. So now we're in due diligence and we say, okay, we need this AC fixed. Seller and buyer agree. They sign their due diligence request form. Everybody is happy. They're going to go ahead and fix it. Or we can talk about the windows that we had in this deal where the windows didn't work as intended because we couldn't open them. They were painted shut. And we asked the buyers asked the sellers to make the windows work as intended. And they neglected to do that on our reinspection at the day before close. So talk about what happens then. So we've agreed that we're going to make we're going to go ahead and make that repair. The seller agreed, and then the seller just doesn't do it.
Yeah. So in this case that we just had recently, once the seller at due diligence agreed to the terms that you requested to make the windows fully operational as intended, once they agreed to that, that became part of their obligation, that specific fix. So when they agreed to it, and then after due diligence ended, didn't perform that, and then as you discovered, I think it was the day of or the day before closing, that they weren't working, they at that point are in breach. Now, as far as the buyer's options in that situation go, because the seller's breached, they can unilaterally terminate the contract and theoretically be due back not just their earnest money, but also their due diligence and any reasonably incurred expenses like inspections, surveys, things like that. That being said, you're only going to get that money from the seller in a breach situation if they agree to that termination with those terms. If they refuse to sign it, if they refuse to give that money over, you would then be looking at litigation, which is costly, and litigation itself can oftentimes is more gray than the black and white of real estate contracts.
Gotcha.
You may not know exactly what the outcome is going to be, even if you feel reasonably confident in your case. Like I think we discussed, a judge could feel that, the windows do open, maybe they don't stay open, but they work, their windows, they do their thing. I wouldn't have agreed with that finding, but who knows how they would have felt about it.
So I typically, in my due deal, when I represent a buyer, I try to counsel my buyers to ask for repairs in the form of seller credit, because, as we found in this, and it just wouldn't, this part, the sellers wouldn't agree to a credit. So we had to go that route. So let's talk about the other. So since it's like he said, she said at the day and the day before close, when the seller makes repairs, and I tell my buyers all the time, the seller is going to make the least repair possible and the buyer wants the best, repair possible. So it's best to get a contractor out there and to go ahead and get, quotes on it, and then get that money so you can do it after close. So let's talk about how those work on the contract. How do we do that? So we don't have to sue people, Yeah,
so I'm glad you brought up seller credit, because if it's something relatively minor that's not dealing with any major function of the home, like the foundation, the roof, because lenders aren't going to want anything like that on the CD. They're not going to approve that. Also, anything over us, if you're talking about a multi-$1,000 fix, again, lenders probably aren't going to approve that. If it was, you have to replace a couple doors and it's going to be $500, you could probably get away with that as a seller concession that's going towards that. But in our situation, where we wanted to make sure that we could proceed with closing on time, but also that the buyers would reasonably have the funds necessary to fix the windows, we went with the
that was the deal before that. No. So you're talking now about the deal before that, where that was a big disclosure issue for me, because it was there was roof issues, there was plumbing issues.
Oh yeah.
Yeah. So we got a credit, and we had to get a bunch of contractors out there, and it was about $25,000. So
that one we went escrow for the sake of the amount of money, and because the lender never would have agreed to it. But we did an escrow for the windows as well, just because we wanted to keep things.
Oh, that's right.
Along.
We did do an escrow for the windows. You're right.
Yeah, only because we wanted, because you found out so close to closing date, we didn't want to mess things up on the lender's side or have to go back and change or rearrange numbers. So we went with the escrow agreement again. Now, we probably could have gotten away with a seller credit, but in the interest of time, we did the escrow agreement. But you're right, the deal before that, where it was, like you said, roof, it was crawl space issues with, I think, moisture.
Yeah,
serious issues that we had to go with an escrow agreement with. And basically, for the people watching, what that will do is it sets money aside from the seller's proceeds, which can then be used after closing to make those repairs. And then typically whatever's left over goes back to the seller afterwards.
Now, if I'm remembering correctly, on the property disclosures on that deal, they did do no representation. So when a buyer is looking at a house and the seller does no representation, sometimes those were investors. So it was a rental property. So they, would say, oh, we didn't live there or whatever. We found it hard to believe that they didn't know about these problems, and that's kind of why we had some leverage to get as much money as we did. But if they had if they had gone a different route and said, no, there were no issues on anything, that might have been a case where we could have known, that sellers would have been at fault on that, or no. We still would have had to get, when we get people out there and say, oh, there's active leaks in the bathroom, and there's leak in the roof, and there's water in the crawl space, I mean, there was just, the plumbing was backed up. We tried to scope the plumbing pipe and it was actually, we couldn't even scope it. So like at that point, would you have it? I'm not going to hold you to it, but like sellers, like no representation on that would be the best way for them to go, just because, they're just saying, nope, we're throwing our hands up, but we're not going to tell you anything.
Well, yeah, buyers still have the right to investigate, but you can still sell properties as is and make no representations at all.
Yeah.
And then the buyer in that situation is taking on the risk that if they don't discover it, then it's sort of on them.
Yeah. So it's a buyer beware state, but we do have some rules.
Yeah.
So I guess caution, when you're looking at houses that, the seller does mark no representation. And then caution to sellers is if you know something, you either should fix it or you should disclose it. Because if it comes up and if we find out you knew it, then you could be in trouble, like in the contract.
Yes. And I think with sellers, or stating that something is in a good working condition, and then it not being in that condition. There's some that are so obvious that I think that the standard really is they knew or they should have known. If there's water pouring through the roof and you said you didn't know, you should have known, if that makes sense.
Yes, that definitely makes sense. Okay, so just to recap on the contract, what section is it that we're talking about? I think you said section 8.
Yes, seller obligations specific are in section 8, but you're going to see more about due diligence on page 2 and 3.
2 and 3. Okay, so we're going to do, Josh and I on future, we talked about this earlier. We're going to go through the contract and talk about seller and buyer obligations. So if you like this content and you want to subscribe, please subscribe below. And again, I'm Maureen Mahood with Sell Your Home Charlotte here in beautiful Charlotte, North Carolina. And Josh, introduce yourself again.
Josh Lipack here with Grabowski Law.
All right, everybody have a great day and thanks for tuning in. Bye.